Well, good afternoon, everybody, and welcome to this webinar where we're going to be talking about competition post-Brexit. Although probably for many of you at the moment, it doesn't actually matter what the topic is, as long as it offers some sort of respite from the peculiar torture that is monitoring online schooling. So nonetheless, we have sorted out a remarkably knowledgeable panel to talk about a range of issues concerning competition issues post-Brexit. Now, there is no way in the course of an hour we're going to cover all of the issues. And of course, along the way, we're very interested in anyone sending in questions to the Q&A function on Zoom. We will try and pick stuff up along the way, and we'll try and put some pauses in case people have questions further during the course of the session. But broadly speaking, the way that we thought we would deal with things today was, first of all, we're going to have James Burke, who is going to talk to us a little bit about what EU law we still effectively have in the competition field, because, of course, we're essentially now in a position where there can be a degree of divergence. We need to bear in mind what still remains and how it functions. Then we thought we would move on and look at aspects of how Brexit and competition law is going to work in relation to damages, private damages cases particularly. So we're going to break that into a series of small sessions. First of all, Laura John is going to be talking about follow-on cases and what Brexit's going to mean for UK litigation in relation to follow-on matters, or what it may mean. Josh Holmes, QC, is then going to pick up some observations about the bindingness of European and other decisions, which has been the subject of what I think he will describe as some of the most entertaining litigation that the country has seen in the last decade. I'm sure he'll bring it to life through the medium of dance in due course. Then we'll go back to Laura to talk a little bit more about damages and what it means for standalone cases. James will then reappear to discuss a little bit more to do with the interaction between the CMA and the European Commission, whether or not there's going to be a sort of beautiful making of daisy chains and holding of hands and a spirit of harmony between the regulators, or they're going to model themselves on an Ursula von der Leyen vaccine standoff model for the future. Then finally, we'll turn to the mighty Robert Palmer QC, who will be talking about issues concerning sectoral regulators, which frankly, everyone perhaps is struggling to deal with, how Brexit is going to affect issues to do with competition with sectoral regulators, and we look forward to his insights on that. So without further ado, I'm going to pass it over to James to talk about what EU law we still have and what has died in the process of Brexit. Thanks very much.
Thank you, Daniel. So I'm going to give a quick overview of changes to 4 categories of retained EU competition law. The key instrument of change is the Competition EU Exit Regulations 2019, known as the Competition SI. It amends or revokes more than 30 legal measures and is basically a gargantuan SI, so I really will be simplifying. The first of my 4 categories is EU regulations. So EU regulations were carried into domestic law as retained EU law under Section 3 of the EU Withdrawal Act 2018. But Schedule 3 of the Competition SI has revoked certain key EU regulations as of the 31st of December 2020, including, importantly, Regulation 1/2003 and Regulation 773 of 2004. So that represents a seismic shift in the way competition enforcement will take place in the UK. I should note that the EU merger regulation has also been revoked. However, the EU block exemption regulations remain part of EU or retained EU law, and they're rechristened as retained block exemption regulations. The Competition Act 1998 has been amended to build them in. So they include, for example, the vertical block exemption regulations, the motor vehicle regulation, and the technology transfer regulations. So this means we have a slightly odd world where we have parallel regulations in the EU and in the UK. although the UK set has weeded out references to EU law. So that's going to be a possible source of divergence in going forward. For example, the European Commission has already said that, the European Commission is already consulting on amendments to the verticals block exemption regulations and the vertical guidelines. Only last week, the CMA, for its part, announced that it's also going to review the retained vertical block exemption regulation. So it'll be interesting to see how they develop in parallel and whether there'll be any significant changes. The second category of law I wanted to mention briefly is directives. As a rule, directives are not carried over as retained EU law by the Withdrawal Act. That is subject to an exception for provisions of a kind recognised by courts, which Jack Williams has helpfully blogged on in a blog on our website. But domestic law which implements any directive is part of retained EU competition law. So, for example, the domestic provisions implementing the damages directive are part of national law. I think Laura will talk more about them. However, new EU directives which have not been implemented are not going to be part of domestic law in the UK. So, for example, my understanding is that the ECN Plus directive, so that's one of 2019, which coincidentally is due to be implemented by member states today, 4th of February, will not form part of UK law. And that's just going to be typical of a divergence that will happen going forward, where new EU law will not become part of UK law in general. My third category is EU court judgments on competition law, and I'll spend a little bit more time on this one. So, as a general matter, under the EU Withdrawal Act, questions on the validity, meaning, or effect of retained EU law need to be decided in accordance with EU case law from before the 31st of December 2020. So that is retained EU case law. For future EU case law, so new stuff after the 1st of January 2021, national courts are under a much lesser obligation, which is that they may have regard to it. And I should just mention in passing that for the retained EU law, so the older stuff, there's an exception for the Supreme Court and the Court of Appeal, which have more freedom to depart from that case law. What I want to focus on, though, is the special regime for competition cases. So Section 60 of the Competition Act 1998, which previously helped to ensure consistency with all EU case law, no matter when it was handed down, is repealed with effect from the 31st of December 2020. That's the starting point. We now have a new Section 60A of the Competition Act 1998, which is a much weaker provision, in my view, than the old Section 60. So the default position under Section 60A is that the UK courts and domestic competition authorities must act to ensure no inconsistency between their decision on a competition law issue and decisions reached by EU courts which precede the 31st of December 2020 and which determine a corresponding issue under EU competition law. So again, there's no consistency obligation with respect to future EU case law. It's only the past stuff. But Section 60A is subject to various exceptions which allow departure from even the old stuff, even the old EU case law. So the court or competition authority does not need to ensure consistency if it thinks it's appropriate to act otherwise for various reasons, including differences between the markets in the UK and the EU, developments in economic activity since the EU decision was taken, differences in law between the UK and the EU. Also, in light of generally accepted principles of competition analysis, which strangely makes it sound like the EU courts may not have been applying those principles. I'd be interested to read any judgment which applies that exception. Or there's also a very broad exception, which is the particular circumstances of the case. So the precise scope of those exceptions will, they're bound to be an issue in litigation. I think it's interesting that the CMA has said in its very helpful December 2020 guidance on its role post-Brexit, that the exceptions to the consistency principle are a limited and specified set of circumstances. So that, I think, is a fairly clear indication that the CMA is keen to maintain consistency going forward with that older case law. I'm not going to talk about the binding effect of EU decisions because I understand my colleagues will talk about that in the context of damages cases. So finally, my fourth category is the competition treaty provisions, namely Articles 101, 102, and 106 TFEU. The very short and obvious point is that after the 31st of December 2020, they are no longer recognised in domestic law. I'll stop talking. Thank you.
Cheers, James. Thanks for that introduction. I think that frames where we are. Brexit did mean Brexit in relation to a large pile of EU law, but since we'd actually copied a lot of it out into our domestic law, the question of the extent of divergence we're going to face in practical terms is something that I think hangs over this discussion more generally. Now, with that, I'm going to turn to Laura John, who's going to be talking about private damages, which is a joy for everyone.
Well, it's going to be a whistle-stop tour of private damages because there's a lot of ground to cover and not a great deal of time available. So I'm going to focus on the two main basic questions that we need to be thinking about when we talk about damages claims. The first is which Commission decisions we can actually use for follow-on proceedings going forward and which we can't. And the second one is limitation. So starting with the first question, the answer is buried deep in the legislation that James referred to. So I've got some slides if Chris is watching and he can put them up on the screen for me. There we go. So these are the two main pieces of legislation that are available. Sorry, my screen has just gone. There we go. The 2019 regulations and also the 2020 regulations that amend them to reflect the withdrawal agreement that was settled during the transition period. And what we've got on these slides is just the relevant legislation so that you can see what I'm talking about as we run through. Then I'll summarise at the end where we get to. Chris, can we have the first slide, please? So this is part 6 of Schedule 4 to the 2019 regulations. The starting point is paragraph 14, and in particular 14.2b. And what this says is that we can continue to bring any claim after IP completion day. That's implementation period completion day. That's the terminology used for the end of the transition period. So any claim that you could have brought before the end of the transition period, you can now bring after the end. So far, so vague. Then paragraph 15, as you can see, says that the enactments mentioned in paragraph 7 have the effect as described there. If we turn on to the next slide, this is paragraph 7. And what this sets out is modifications to part 1 of the Competition Act, including to 47A. We can see under subsection 3 that the modifications set out in subparagraph 4 will apply except in cases where the Commission has continued competence after the end of the transition period in accordance with Article 92 of the Withdrawal Agreement. And then the modifications set out in section 4 are that references in part 1 of the Competition Act to a decision of the European Commission finding an infringement of Article 101 or 102 do not include a decision made on or after the end of the transition period. So what do we mean in subsection 3 when we refer to cases where the Commission has continued competence? That's on the next slide. Here we go. And what we can see here is that the Commission has got an ongoing competence in any case where the procedures were initiated before the end of the transition period. And subsection 3 of Article 92 tells us what that means for antitrust purposes. We can see that this is concerned with the initiation of proceedings in accordance with Article 2 of Commission Regulation 773/204. Now, this is something that we're not really used to thinking about in damages proceedings. We look at press releases around the dawn raids that the Commission conducts. We look at press releases around the statement of objections, but we're not used to thinking about this, this additional internal step that the Commission takes of initiating proceedings. If we turn to the next slide, we can see what Article 2 of that regulation says. And the answer is, it doesn't actually say very much. So this tells us the latest date by which the Commission has to initiate proceedings. But clearly it could have done that at any point prior to the dates that are specified in this article. So where does that leave us for practical purposes? Well, the Commission doesn't conventionally announce when it's commenced an investigation. I understand from speaking to a couple of people that it may be the Commission has started making those announcements in the last few months of last year. I think James may come back to that in due course, but it may be that the position is actually fairly clear in relation to the cases that are potentially going to fall under this heading. But insofar as there may be any ongoing uncertainty, it's possible that we're going to have to think about writing a letter to the Commission and just asking them, in connection with any particular investigation, did it formally initiate its proceedings before the transition period ended? I don't know whether the Commission will answer that question. It's not immediately apparent to me that there's any reason why they wouldn't. But who knows, we can but write and see what unfolds. So where does that leave us, all of that legislation? What decisions can we actually use for follow-on purposes? Well, the short answer, having looked at all of that, is any decisions that were taken before the end of the transition period, we can still issue claims that are based on those for follow-on purposes, assuming you're within time to do so. That's the effect of paragraph 14 of Schedule 4 that we looked at on the first slide. The other decisions that we can use are those that were taken after the end of the transition period, provided that the decisions are the culmination of proceedings that had already been initiated before the end of the transition period. In practice, that means we're probably looking at potentially quite a long tailing off period. So you'll recall that a year ago, a couple of years ago, there was a concern that we were facing an imminent cliff edge and all damages litigation in the UK was about to plummet off it and move across the channel to the Netherlands or Germany. That concern may materialize at some point in the future, but it's not going to happen now. We can still issue follow-on proceedings in the UK for potentially some time to come. The second question to think about then is the question of limitation. And on this, I'll start by recalling where we were before the end of the transition period. The Damages Directive had been implemented in the UK. We had Schedule 8A added to the Competition Act. As James said a moment ago, that is retained EU law. It's part of our domestic law going forward, so all of that stays. And in Schedule 8A, paragraph 21 introduced a new stop the clock mechanism for limitation periods. And this stop the clock mechanism applied in any situation where a competition authority was investigating conduct that was complained of. It provided that time doesn't run for limitation purposes during an investigation, it gets paused. Now, under the Brexit legislation, If we can have the next slide, please. Under the Brexit legislation, we have some amendments to the stop the clock mechanism, and the amendments are the underlined text on this slide. And you can see that the amendments that are made concern the date at which the clock starts again. So it stops at the beginning of an investigation. It starts again at the points specified in paragraph 3. And you can see under A that for the purposes of decisions taken before the end of the transition period, the position remains the same as it was prior to the amendments, essentially. The point of real interest is section 3C. And this is of interest because we have this tailing off period for Commission decisions, investigations that continue to run after the end of the transition period. Now, if those investigations take some time, the amendment to this provision means that notwithstanding the investigation is ongoing, the clock will restart 1 year after the end of the transition day, end of the transition period. And that's an important point to note because in some cases, depending on the circumstances, of course, but in some cases, even though there is provision made that says you can still bring a follow-on claim based on these legacy decisions, you may nonetheless find yourself in a position where, because of the applicable limitation rules, you have to go ahead and issue your claim on a standalone basis while the investigation is ongoing and wait to see what the outcome might be in due course. Now, I think at that point, I'm probably timed out. I'll come back to standalone claims in a moment.
Thank you, Laura. So we've heard a little about what has died. We've heard more from Laura about what will live on in terms of Commission decisions, both taken before D-Day, B-Day, but also those that were being investigated. We'll now turn to Josh Holmes, QC, to talk about what the force of those decisions are. I mean, what's the point, frankly?
Josh, you're on mute.
You're on mute.
Sorry.
Very good.
That's a
Thank
proper
you.
QC start to a submission, that one.
Indeed. Can you all hear me now? Yeah, very good. So as Daniel says, my topic is the binding effect of recitals in European Commission decisions, which has been a delightful parlour game in follow-on damages litigation. I won't attempt to do justice to it through the medium of dance, as Daniel volunteered me for, but I do have a few observations based on the recent case law in the trucks litigation. The issue on its face is a deceptively simple one. As we all know, European Commission decisions are a bit like icebergs. They consist of a very short operative part comprising the articles, and these set out the bare bones of the infringement, describing in short form what the infringement consisted of. For example, a single and continuous infringement involving the coordination of prices and other terms of dealing, the article of the treaty which is infringed, the affected sector or market, but none of the underlying evidence. They also set out the fine and any direction to desist from infringing conduct, and they give details of the addressees. But the overwhelming bulk of the decision, including the detailed factual basis for the Commission's finding, is to be found in the recitals which precede the operative part. Now, the decision itself, as contained in the operative part, is binding as a matter of European Union law, at least once it becomes final. And this is reflected in Article 16 of the Modernisation Regulation, which precludes a national court
from taking decisions that run counter to the Commission's decision. And until recently, it was also binding in all circumstances in UK law, as was reflected in Section 58A of the Competition Act, which provided that where a claim is brought in respect of an infringement decision once final, that decision is binding, and that finality was achieved once the time for appeal had expired or an appeal had been brought and determined. The question which then arises is whether, and if so, which of the recitals underlying the decision are also binding. And that question arises in particular, of course, in the context of follow-on damages litigation, where the Commission decision is relied on to establish liability. And as Laura has indicated, despite the UK's exit from the European Union and the exhaustion of the interim period, there are still a number of circumstances in which Commission decisions will still form the basis for litigation and will need to be considered by UK courts. And to that extent, the issue of binding recitals will remain a pertinent one. Just to highlight the circumstances in which that might occur, a decision will of course remain binding in the context of a follow-on claim which is already brought before the end of the interim period. Secondly, follow-on claims remain possible under the transitional provisions in relation to decisions adopted prior to the end of the interim period. Thirdly, Commission decisions will continue to have force in the UK in relation to investigations where the Commission has continuing competence, as Laura has described, and those could be relied upon. And fourthly, even in relation to decisions adopted in the future in relation to investigations not within continuing competence, a court may still have regard to a Commission decision under Section 6.2 of the EU Withdrawal Act. Now, exactly what weight should be afforded to it will need to be worked out. For example, to what extent would it have any evidential force, having regard to the decision in Hollington and Hewthorne that a criminal conviction or regulatory finding of liability is generally inadmissible in civil proceedings. But there's at least the possibility of a decision needing to be considered and a view taken as to which parts of it are binding. Now, for present purposes, then, it's clear that the binding scope of a Commission decision is likely to remain an important issue for some time. And the latest guidance on the issue, as I said, can be found in the judgments of the Competition Appeal Tribunal and of the Court of Appeal, determining a preliminary issue that arose in the trucks litigation, which is currently pending before the tribunal. As regards the European Union test, the following points emerge. First, the basic test is now quite well established and wasn't disputed by any of the parties in that case. A recital is binding insofar as it constitutes an essential basis or necessary support for the operative part, or is necessary to understand the operative part of a decision. Secondly, the recitals can clearly be relied on as an aid to the interpretation of the operative part, insofar as the operative part is unclear or ambiguous. Thirdly, however, the tribunal accepted in the trucks case, having considered the European Union case law on the point, that recitals may also be binding in other circumstances as well. Recitals of a decision may be challenged as erroneous in legal proceedings in the European Union courts, where they affect the substance of what is decided in the operative part. So, for example, we're well familiar with appeals before the European Union courts in which, for example, an addressee of a decision challenges the duration of the infringement as found in the operative part on the basis that evidence in a particular recital to support the duration has been misconstrued. That would be easily open to challenge as a basis for restricting the duration as found in the operative part. So on that basis, if no appeal is brought, or an appeal is brought but fails, the Commission's finding in the relevant recital should properly be regarded as binding alongside the operative part itself. Fourthly, the Tribunal regarded findings essential to supporting the fine, which is also set out in the operative part, as equally binding in follow-on proceedings. So it's not merely those which go to the substance of the infringement, but those which are found anywhere in the decision, which will be binding. Fifthly, where a finding of infringement is sustained by multiple pieces of evidence in a number of recitals, those individual pieces of evidence cannot be regarded as an essential basis of the decision. So on that basis, the Tribunal accepted that a number of recitals were binding insofar as they described the collusive behaviour in broad terms, but it determined that the recitals which, but it rejected the notion that the recitals setting out the details and examples of collusion were binding insofar as there were multiple pieces of evidence, all in support of the same broad conclusion. And sixthly, beyond these general points, the application of the test is necessarily fact-specific and needs to be considered on a recital by recital basis. So that rather grueling process may still arise subject to the guidance that the Tribunal has given. The other interesting point of note from the litigation is of slightly narrower relevance. It's relevant specifically to settlement decisions, and it arises out of the UK legal concept of abuse of process. And in relation to settlement decisions, the Tribunal concluded, and the Court of Appeal agreed on subsequent appeal, that it could constitute an abuse of process for settling parties to deny findings contained in the decision to which they had been prepared to admit in the context of the settlement procedure before the Commission. And here the Tribunal was obviously influenced by the many advantages and benefits which settling parties gain from settlement, the fact they face a reduced fine, the fact that the factual findings are greatly condensed as a consequences of their settlement, making follow-on damages claims more difficult. And in those circumstances, having accepted the contents of the decision and its main factual findings, the Tribunal concluded that it would indeed be unfair and an abusive process for settling defendants to deny or not admit facts which are set out in the recitals to a settlement decision. That was subject to two particular caveats. First, a settling defendant can plead a positive case in its defence, which contradicts recitals in a decision in circumstances where the defendant can contradict the recital on the basis that it does not accurately reflect the underlying document referred to. So factual errors of that kind can be exposed in subsequent litigation, and the underlying document can be relied upon. Secondly, a settling defendant is not precluded from relying on new evidence which it could not reasonably have had access to at the time of the Commission decision. And to that extent also, it can look behind the factual decision, findings in the decision that it was prepared to admit. But subject to those 2 points in the specific context of settlement decisions, there is that added constraint under national law on the ability to deny binding recitals, which to a considerable extent will replace really as the important and informing test, the consideration of European law, which applies more broadly. So on that basis, I'll hand over to, I think we're going back to Laura now, are we?
Yes. So we've heard about what's gone, we've heard about what stays, we've heard about the way in which the English courts have indicated that what stays is particularly important from Commission decisions, especially in settlements. And we're going to see that played out, what the practical impact of that is in things like the trucks litigation, potentially the foreign exchange litigation, both of which concern follow-on claims in relation to settlement decisions. We want to talk a little bit about the regulatory interactions, which James and Rob are going to talk about, but it's wrong to move straight to that without a very brief comment or two about where we sit now with standalone cases in circumstances where, obviously, when you're talking about a standalone, you're talking about an infringement, and the questions of to what extent our law will diverge from European law may loom large. But Laura, do you want to just make one or two brief remarks on standalones before we shift over to regulatory issues?
I'll be as quick as I can. Yeah, so at the point at which this becomes interesting is when we hit the point where you have to start pleading your breach of Article 101, 102 as breach of a foreign tort. And what that's going to mean in practice, the short answer is no one really knows. We've had claims that have pleaded breach of various foreign law provisions. Air Cargo was one, Microsoft Mobile was another, but those cases haven't reached trial, so we don't know how it's going to play out in practice. There are two things to think about. The first is we know that foreign law has to be proved by way of expert evidence. So we can do some thinking around that. We know that's going to mean that there will be an extra layer of expense for clients in bringing these claims in future. Initially, we might see some familiar figures brought in as experts. Perhaps we might see former Judge Vida on one side and former Judge Bellamy on the other. And if they run that as a hot tub, we will sell ringside seats. As time goes on, people may have to start looking a little bit further afield to find their experts as EU law begins to diverge more and more. As James started explaining it, maybe we'll have to start looking for experts actually within Europe to back up our clients' cases on those particular arguments. The second thing to think about is going to be what's the ongoing relevance of Commission decisions. So in circumstances where the decisions are not binding, but there is still a decision in the background, what's the significance of that going to be? Now, I think there are quite a few different views about this floating around. Personally, my view is that the fact the decision is not binding is actually not likely to make a great deal of difference in practice. It will be open to defendants to argue that 101, 102 were not breached, even though the Commission says that they were. They will be entitled to run that argument. The decision is no longer binding. And it may be that they will be able to find an expert who is prepared to support them in running that argument. But for my part, I think the chance of persuading a judge that he or she should conclude there is no infringement of the foreign law provisions in circumstances where the responsible regulator has said there was a breach, it seems to me the chances of that happening are vanishingly small. I will stick my neck out and go that far. I may eat my words in a few years' time, of course, but I don't think that's going to be the main point of difficulty for claimants going forward. I think if you are a claimant wanting to use a Commission decision, actually, your point of difficulty is going to be whether that decision is available at all to use. If you've got a decision, you're in a fairly good place. The problem will be in circumstances where there is an investigation ongoing and you have to try and persuade the court that they should wait until the decision becomes available. We've all had the experience of the judge pursing their lips and taking a sharp intake of breath as they realise that it's going to be another 5 years before a case comes to trial. And in practice, I think it's unlikely that those
I'm not sure. Laura, we lost you for a bit. Can you hear us?
You dropped off, or did that happen?
Yeah,
to
we lost you for a moment there, Laura. So do you want to just conclude and then we'll hand over to James?
I'm sorry, I think I had just about finished that thought anyway. My point was that if you are a claimant bringing a claim in circumstances where the Commission is investigating, but you're not within the tail end legacy provisions, your main problem is going to be persuading the court to wait until a decision is available. It's not going to be the fact that the decision is not binding at the end of the day.
Yeah. Okay, so we've got the difficulties with or opportunities with using Commission decisions, but we've also got the possibility that the CMA will be opening parallel investigations and considering these matters alongside. And James, I think you're going to pick up on the relationship between CMA and Commission here.
Yeah, thank you, Daniel. So I don't think that this is going to be a vaccine standoff type situation. I think that the competition enforcers are more likely to be in their own bubble, and there'll be a strong desire to continue to cooperate. They have been cooperating for years, and I think the CMA and the European Commission are fairly like-minded as competition law enforcers, and they will be well aware that international cooperation is very important for competition enforcement. But they are going to face significant challenges, right? First of all, the UK is no longer part of the ECN, which is the key forum for cooperation. Second, as Daniel just mentioned, there's a real risk of parallel enforcement going forward. Third, we don't have the safety mechanisms under the Regulation 1/2003, which we used to have to ensure consistency. And fourth, and I think very importantly, there's no cooperation agreement in place right now, like the EU has with many other countries, including the US, Japan, South Korea, Switzerland, etc. I understand that there was an ambition during the Brexit negotiations to get such an agreement in place, but it fell by the wayside because the negotiators had other priorities. The Trade and Cooperation Agreement has some fairly woolly language, I think, on cooperation. And it also foresees an agreement between the Commission, the NCAs and the UK authorities on cooperation on competition law, including information exchange. And I saw a press report yesterday that the UK government is very keen to have this in place by the end of the year. But the reality is that the locker is quite empty right now. So I'm going to refer to two types of antitrust investigations going forward to illustrate some issues from a cooperation perspective. So the first type of case is what the CMA is calling continued competence cases. And these are the ones that Laura has referred to already under Article 92 of the Withdrawal Agreement, where the Commission has initiated proceedings before the 31st of December 2020, and which, to simplify, have some sort of a UK angle. And just to pick up on the debate regarding what it means to initiate proceedings, I see that Nicholas Kahn has made some helpful remarks on that. Another point perhaps to take into consideration is that Article 92(3), subparagraph 3 of the Withdrawal Agreement says that the EU is required to provide the UK with a list of these cases by 3 months from the end of the transition period, so the end of March. I don't know to what extent that list will be publicly available or not, but it would certainly be a very helpful list to have to know what these continued competence cases actually are. So in terms of cooperation on these cases, to simplify, the old rules apply. So even though the relevant sections of the Competition Act on the CMA assisting and cooperating with the Commission in general have been revoked, they still apply, according to Schedule 4 of the Competition SI, for these continued competence cases. So that means the CMA can carry out inspections for the Commission. It means there will be information sharing. And actually the CMA will be invited to advisory committee meetings, which is quite interesting. On the CMA's investigative powers, I'd make two quick points. One is that the CMA cannot open investigations into competition concerns which are the subject of continued competence cases. So that's similar to the pre-Brexit position under Regulation 1/2003, Article 11.6. But the Commission may open an investigation in these cases insofar as they concern effects arising from conduct after the 31st of December 2020. So if the conduct continues after that date and it affects trade in the UK, then the CMA can investigate and apply the Chapter 1 and 2 prohibitions. So again, this is where we can have parallel investigations by the Commission and the CMA. Of course, it'll be up to the CMA to decide whether it's really necessary to have a separate CMA investigation. That'll be a priorities decision for it. And it has said in its December 2020 guidance that I referred to earlier on, that it would typically expect to liaise with the European Commission, as it would with other competition authorities, in the context of parallel investigations. But we have to wait and see what exactly that's going to mean. The second type of investigation I wanted to briefly refer to are cases where neither the Commission nor the CMA has initiated an investigation by the 31st of December 2020. So again, this is a situation where we can get parallel investigations. The CMA can only apply its domestic rules for conduct from both before and after the 31st of December 2020. As for the Commission, it can still have jurisdiction, of course, under its implementation and effects doctrines over the conduct of UK businesses which affect competition within the EU. So for example, if you get a UK undertaking which participates in an alleged cartel that has an impact on the EU, that is subject to investigation by the European Commission. But importantly, in these cases, my understanding is that the Commission won't be able to dawn raid in the UK, and the provisions of the Competition Act, where it could ask the CMA to carry out inspections for it, are revoked. So the Commission can only issue RFIs as its main investigative tool. So absent a cooperation agreement between the EU and the UK on this, it's very unclear to me as to how they are going to cooperate in these investigations. And I suspect that both sides will be very keen to get a cooperation agreement into place as soon as possible. I'll stop talking there. Thank you.
That's great. Thank you very much, James. That's extremely helpful. I mean, it feels like there are some real impediments, unsurprisingly, from the parallel scheme of investigations. But it is interesting to think about the extent to which, if you get market definition that applies across the whole of Europe, including the UK, how in practice those things are going to be dealt with in due course. Now, we're focusing there on the general competition issues that arise. I'm going to turn now finally to Rob to talk about sectoral regulators and how they operate in relation to these issues and whether the TCA has any impact here. Rob, thanks very much.
Thanks, Daniel. Yes, I'm going to talk about that other dimension of regulatory cooperation, the changes in regime for sectoral regulation. And it's important to make the obvious point first, which is the single market was long characterized by an acknowledgement that the simple application of ex post competition law that we've been discussing so far is by itself inadequate to ensure the effective and competitive functioning of sectors of the economy, such as the utilities, telecommunications, postal services, financial services. So until Brexit, all were subject to EU regulatory regimes designed, in the case of utilities, for example, telecommunications, to liberalise markets formerly characterised by national monopolies to make them competitive, efficient, non-discriminatory, whilst at the same time providing for universal service obligations, so allowing an appropriate but not undue degree of cross-subsidy to ensure certain groups of consumers were properly protected. Now, in each case under the old EU regime, those objectives were given practical effect by national regulatory authorities in each member state, Ofcom, Ofgem, FCA, each of whom were the subject of pretty rigid and prescriptive sets of rules and processes, but within those rules and processes often enjoying a wide degree of regulatory discretion. And the underlying logic motivating those regulatory objectives, of course, doesn't change at all with Brexit, so far as the UK's own domestic markets are concerned. And national regulators will continue to regulate the markets as they did before, largely, at least initially, under arrangements which continue as retained EU law. But after years of codependence, these markets, our domestic market and EU markets, have become closely enmeshed, and questions will arise to greater or lesser extents, depending on the sector, about how the regulatory regimes are going to interact in future. a greater extent, for example, financial services, most obviously, which is very much up in the air still. We don't know where that is going to fall. To a lesser extent, perhaps telecoms, as I'll come on to describe. So where do we find all this? Well, the first thing to say is that the withdrawal agreement itself had absolutely nothing to say about the future of sectoral regulation. Anything that was said in the political declaration. And so we now have to look to the TCA to understand what has been agreed and indeed what hasn't. And in the TCA, Part 2, Heading 1 deals with trade, and we need to look principally at Title 2, which deals with services and investment, as well as Title 8 on energy. There's separate headings about aviation, road transport. I'm not going to attempt to get into that. So let's take telecommunications to start with. And of course, the starting point there is that we've just had the introduction of the new European Electronic Communications Code, which replaces and consolidates the old framework directive and specific directives. And that had to be implemented in member states' national law by the 21st of December 2020. So just before the end of the transition period, when EU law continued to apply, obviously, and in compliance with that obligation to implement, the UK did implement that new directive with effect from the 21st of December. But the same statutory instrument which implemented it then introduced a further set of changes to disengage from elements of the EU regime just 10 days later at the end of the transition period on the 31st of December. So those regulations achieved full implementation for 10 days and then rode back and coupled with the effect of 2019 regulations, which have been previously made to sort of de-EU the operation of the system, for example, removing requirements to consult the Commission and so forth. And one of the big changes in terms of regulatory cooperation, as far as that's concerned, is that whereas previously Ofcom had a duty to have utmost regard to, for example, Commission recommendations, BEREC guidance, now that's been changed so that Ofcom simply may have regard to those matters if they think they're relevant. And that could be important because that duty to have utmost regard had a sort of quasi-prescriptive character in that you could only then depart from it if you gave express consideration to it and came up with sufficiently good reasons to depart from that. So there's greater flexibility. But the essentials of that existing regime will remain. So what's in the TCA? Well, about 7.5 pages out of an agreement of 1,400 plus pages. What's there, of course, applies to both parties, the EU and the UK, on an equal basis. So by definition, what it prescribes for the future reflects, by and large, what is already there in the EU regime. Given that the EU's future regulation, now in the EECC, must comply with the principles set down for this future cooperation. And similarly, what we have done already to implement that will also be designed to comply with those principles. So what does it provide? Well, the first thing is it requires the continued existence of an independent national regulatory authority as before. It requires a right of appeal against Ofcom's, in our case, Ofcom's decisions. Interestingly, no equivalent to the former requirement under Article 4 of the Framework Directive as to the appeal standard needing to have regard to the merits. So that suggests a pure JR standard would now be compatible. Continued general authorization, but without the current prescriptive list of conditions which may be imposed on the general authorization. Instead, just a general requirement that any condition should be as simple as possible, objective, transparent and proportionate, and related to services and networks provided. So again, indicating that there could in future be some divergence there. And then pretty broad brush, high level requirements imposing a right to request and obligation on providers to negotiate interconnection, obviously a key point, general rights of access and use, which apply to what the TCA refers to as covered enterprises, which means enterprises in the territory of one of the parties established by an investor of the other. So actually established in the territory of the other party, they have the rights to access and use, as do service providers. And the requirement to provide interconnection and access to essential facilities under non-discriminatory terms and principles. And so it goes on. I'm just trying to give the general flavour. What characterises the types of regulatory requirements which persist are broad brush, what I call principle-led requirements, essentially focused on transparency, objectivity, non-discrimination, and retaining such matters as a required mechanism for dispute resolution, which Ofcom, in our case, the National Regulatory Authority, is responsible for providing. So far as competition expressly is concerned within that, there's an obligation to introduce and maintain safeguards against anti-competitive practices, such as anti-competitive cross-subsidization, or the use of information obtained from competitors for anti-competitive purposes. But again, very high level. And the one matter which has attracted any sort of general media comment on the new regime is, of course, on international mobile roaming, where we're no longer subject to the roaming regulation. And that's replaced simply by a pretty loose requirement that parties shall endeavour to cooperate on promoting transparent and reasonable rates for international mobile roaming services. But it's quite explicit that there's no requirement to regulate rates or conditions for roaming services. Will providers depart from the current status quo and start charging roaming services? Perhaps no one wants to be the first to do that. But interestingly, even before Brexit, when you look at somewhere like Switzerland, you do find divergence between different operators as to whether they'll charge higher rates for mobile roaming there. And so that flexibility is preserved. I'll go more quickly through some of the other areas because we must finish, but postal services, just 2 pages on it. Again, very broad brush. License conditions must be transparent, non-discriminatory, based on objective criteria. Financial services, extraordinarily, given how important it is for our economy, just 4 pages in the TCA, but almost all of that just concerned with definitions and less than 1 page actually setting out any substantive requirements. So obviously all of this very much pending future deals in terms of equivalence and passporting, and very much to be worked out, but just a general commitment that internationally agreed standards will be imposed, and those loosely referred to by those, including those adopted by the G20, the Financial Stability Board, the Basel Committee on Banking Supervision, and so forth. Very little detail beyond that. Finally, far more, as you'd expect, on energy, 16 pages we get up to there. But note that the whole of Title 8 on energy ceases to apply on the 30th of June 2026, a possible extension until March 2027. Beyond that, that's the limit of it. And here, there's an explicit decision that the UK won't any longer participate in the EU's internal energy market or the EU trading platform. The entire focus is on cooperation, again, principles-led cooperation with just general obligations to ensure that the regulatory framework is non-discriminatory with regards to rules, fees, and treatment, and customers are free to choose and switch. But not even those obligations apply to cross-border trade. So high-level regulatory objectives set for wholesale markets, balancing markets, capacity markets, but no engagement with the existing capacity mechanisms or rights of EU operators to participate in any capacity mechanism we have in the UK or vice versa. As you'd expect, particular focus on interconnectors in both gas and electricity markets, far more detail there. But beyond that, future cooperation, interestingly, is to end on this, a specific mechanism for ACER still, beyond that allowed for BEREC in the telecoms context, but ACER a specific mandate to develop contacts between the various regulatory authorities and to enter into administrative arrangements as soon as possible to facilitate meeting the objectives in the agreement. So very little which can be relied upon directly, much to be worked out, coordinated, and cooperation at the centre of the new regulatory deal. We wait to see where that takes us.
Thank you, Rob. Well, it sounds like it's, if terse in the TCA, pregnant with possibility for new cooperation, new divergence, and development of some difficult issues in due course. Indeed, we've been trying today to pick up on some of the key legal issues that have arisen. Obviously, we recognise that there is likely to be substantial argument about divergence, both in relation to sectoral regulation, but also in relation to competition matters more generally. And it is going to be interesting to see how courts, both in the EU, but particularly in the UK, and the UK regulators, become more open to consideration of arguments that go beyond, for instance, European law, and turn outwards to other common law jurisdictions like the US or Canada, as of course we've already seen in the context of class action damages. So it seems to us that there is a good degree of uncertainty in relation to a range of topics that will make the progress of European competition law in the UK and UK's competition law more generally a particularly interesting area of activity for some years to come. With that, I think we finish up. I thank all of our panelists for fascinating contributions, and to everyone that's joined. It is lovely to see you virtually, and we hope to be seeing you in the flesh fairly soon. Thank you very much all. Bye.
Bye-bye.